Please be seated. Proceedings are resumed. I recognize the Honorable Premier. Sorry. Madam Clerk.
Motion number 9 of 2016-17, application to the Commonwealth Association of Public Accounts Committees, to be moved by the Honourable Premier, Minister of Home Affairs, Health and Culture.
I recognize the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I beg to move Government Motion number 9 of 2016-2017, entitled Application to the Commonwealth Association of Public Accounts Committee.
The motion has been duly moved. Does the Honorable Premier wish to speak to his motion?
Yes, thank you, Madam Speaker. Madam Speaker, the motion, whereas the Standing Public Accounts Committee wishes to become a member of the Commonwealth Association of Public Accounts Committees, and whereas Clause 3.03 of the Commonwealth Association of Public Accounts Committees Constitution provides that a member committee shall be admitted to the association following a written application submitted by the relevant legislature to the chair of the association, and whereas the application must declare that the legislature supports the application of the committee, be it therefore resolved that the Legislative Assembly confirms its support of the Standing Public Accounts Committee making an application to be admitted to the Commonwealth Association of Public Accounts Committees. Madam Speaker, on the 16th of September, the chairman of the Public Accounts Committee, Mr. Diaz Miller, the elected member for North Side, wrote to me regarding the matter raised in the motion. His letter provides as follows. At a recent meeting of the Public Accounts Committee, it was agreed that the Cayman Islands PAC would apply to become a member of the Commonwealth Association of Public Accounts Committees. In order for our PAC to become a member of the association, we must declare, by virtue of Clause 3.03 of the Commonwealth Association of Public Accounts Committees Constitution, that the legislature supports the application. We are therefore requesting that a motion be presented to the House at the next meeting asking for support of the PAC's application to the CPAC. It is also requested that the motion include the provision for the payment of the annual membership fees. A copy of the CPAC Constitution and the PAC principles are attached for your information. We appreciate your consideration to this request. So, Madam Speaker, the government has considered the matter and has agreed to support the application to the Commonwealth Association of Public Accounts Committees for membership by the Standing Public Accounts Committee of this legislature. And accordingly, Madam Speaker, I have moved the motion and I ask all honourable members for their support.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? I once again recognize the Honourable Premier if he wishes to reply.
Thank you, Madam Speaker. I just wish to thank all members of the House for their tacit support of the motion.
The question is, be it therefore resolved that the Legislative Assembly confirms its support of the Standing Public Accounts Committee making an application to be admitted to the Commonwealth Association of Public Accounts Committee, CAPAC. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. Accordingly, motion 9, Government Motion 9 of 2016-17 has been passed.
Bills, first readings. The Elections Amendment Bill 2016.
The bill has been read a first time and it's set down for its second reading.
The Legal Practitioners Bill 2016.
The bill has been deemed to have been read the first time and is set down for its second reading.
The Education Bill 2016.
The bill has been deemed to have been read the first time and is now set down for its second reading.
The Utility Regulations and Competition Bill 2016.
This bill has been deemed to have been read the first time and is also set down for its second reading.
The Information and Communications Technology Authority Amendment Bill 2016.
The bill has been deemed to have been read the first time, is set down for its second reading.
The Electricity Regulatory Authority Amendment Bill 2016.
This bill has been deemed to have been read the first time and is set down for its second reading.
The Dangerous Substance Handling and Storage Amendment Bill 2016.
This bill has been deemed to have been read the first time and is now set down for its second reading.
Second readings. The Elections Amendment Bill 2016.
I recognize the Honorable Deputy Governor.
Madam Speaker, thank you. I beg to move the second reading of a bill shortly entitled the Elections Amendment Bill 2016.
This bill has been duly moved. Does the Honorable Deputy Governor wish to speak to this bill?
Yes, thank you, Madam Speaker.
Please proceed.
Thank you. Madam Speaker, this bill aims to make the election law compatible with the provisions as set out in the Cayman Island Constitution Order 2009, number 1379, this 19 single-member electoral district boundaries Order 2015, and for incidental and connected purposes. Madam Speaker, this amendment bill also achieves one of the government's key promises to the people in their manifesto, namely, and it's set out in the government's manifesto, amending the election law to establish single-member constituencies in good time for the 2017 elections, thereby giving effect to the desire of the majority of Caymanians who participated in the one-man, one-vote referendum. Madam Speaker, we will remember that some 5,000 Caymanians voted in favor of one-man, one-vote referendum, and members from East End and North Side had also developed a petition as well, which was supported by thousands of Caymanians. So, Madam Speaker, this amendment bill seeks to put in place what thousands of our people have asked for. Madam Speaker, this Honorable House will be aware that an Electoral Boundaries Commission was established in accordance with Section 891 of the Cayman Islands Constitution Order on August 20, 2015. The Boundaries Commission submitted a report to the Governor and to this Legislative Assembly, which recommended 19 single-member electoral boundaries and 19 elected representatives. The report was laid before this Honorable House on the 5th of October 2015 and was approved by resolution on the 19th of October 2015. Madam Speaker, Her Excellency the Governor, under the powers conferred by Section 89(6) of the Constitution, ordered that upon the next dissolution of the Legislative Assembly, the Cayman Islands shall be divided into 19 electoral districts as set out in Section 2 of the 19 Single-Member Electoral District Boundaries Order 2015. This 19 single-member electoral district boundaries order 2015 was gazetted on the 25th of November 2015. Madam Speaker, the Cayman Islands has had a rich and varied history of elections and elected representatives. Historical records show that on the 10th of December 1831, two representatives each were elected for the districts of West Bay, Georgetown, Southwest Sound, Prospect, and Bordentown. The method of election is not known. These 10 representatives, later referred to as vestry, assembled for the first time on the 31st of December, 1831 in Georgetown. Madam Speaker, by 1839, the number of representatives grew to 18, with 4 representatives from Georgetown, 7 for Bordentown, 3 for Spots and Prospect, and 2 for South Sound, and 2 for West Bay. Madam Speaker, in a quite spectacular manner, by 1956, the number of representatives grew to 27, with 4 representatives for Cayman Brac and Little Cayman, 5 representatives for West Bay, 2 representatives for North Side, 3 representatives for East End, 5 representatives for Bordentown, 3 for Prospect, and 5 representatives for Georgetown, for West, yes. Madam Speaker, another dramatic round of election changes came about Madam Speaker, another dramatic round of election changes came about with the introduction of the first Cayman Islands Constitution in 1959, when the number of representatives was reduced to 12, with 3 representatives in West Bay, 3 representatives in Georgetown, 3 representatives in the sister islands, 2 in Bordentown, 1 representative for East End, and 1 representative for North Side. As can be discerned from this brief look back at not only the number of representatives, but also the changes in electoral districts, our electoral system has been undergoing what I can only call continuous change. Madam Speaker, this brings me to the present day and the Elections Amendment Bill 2016, which seeks to accomplish the following: make provisions that allow for retired civil servants to be considered for the post of supervisor in addition to current provisions for senior civil servants. To allow current and former civil servants, as well as persons who never worked as civil servants but have extensive elections experience, to be eligible to be appointed as deputy supervisors, with the provision to adjust the number of deputies as deemed necessary. And Madam Speaker, this is simply to allow us greater choice when we are appointing persons to this high office. We want to ensure that we are getting the very best persons. And some persons, just because they are no longer civil servants or because they're not working in the civil service, doesn't mean that they're not capable of carrying out these duties. To amend the elections law to make it reflect the 19 single-member electoral district boundaries as set out in the 2015 Electoral Boundaries Commission report. Madam Speaker, the bill also provides for logistical discretion for the supervisor of elections to designate polling stations and counting stations that fall outside of the geographical area of an electoral district after the writs are issued, with adequate notice to voters, of course. This amendment is proposed to address past experiences where there were either limited or no suitable structures available in an electoral district, and voters were subject to either harmful or less than desirable conditions when voting. Speaker, I understand this happened in West Bay during the last election. Madam Speaker, I can assure this honorable House that the supervisor and the team at the elections office are making every effort to utilize appropriate polling stations that fall within the geographical boundaries of each single-member electoral district, and this provision provides an insurance policy only of sorts should those plans have to change. Madam Speaker, the qualifications of persons being nominated was a concern to the international elections observers during their mission in 2013. Additionally, a constitutional legal challenge to concerns around the eligibility of our representatives was heard in our local courts in 2013, in which the government was named as a respondent. In an effort to mitigate risks and concerns with the qualification of potential candidates, the bill seeks to amend the elections law by overtly placing the onus on the candidate to be satisfied of his or her qualification. As such, the nomination forms has been amended to reflect this. The form also sets out, for the benefit of the nominating person and the nominating person, the various qualifications, disqualification requirements, which are set out in the Constitution. We want to make it very clear to everyone. Madam Speaker, the bill also seeks to amend the elections law to introduce a new provision to allow for the sharing of information held by government entities to the supervisor of elections to verify the qualification, disqualification of nominated persons. In this manner, the supervisor of elections is more able to effectively fact-check to a large extent the eligibility of the nominated person. Therefore, Madam Speaker, in the event a question arises as to the eligibility of the nominated person based on the diligence carried out by the supervisor of elections and the other relevant election officers, this bill makes provision for the supervisor to petition the court on an expedited basis for a declaration in relation to whether a nominated candidate does or does not qualify to be a candidate pursuant to Section 621 of the Constitution or is disqualified pursuant to Section 62 of the Constitution. The effect of this provision, Madam Speaker, is to ensure that A, only eligible candidates find their way onto the ballot, B, allow for a clear, independent, and unequivocal process to be carried out to determine eligibility, and C, to avoid costly by-elections and frustration of the election process by ineligible candidates participating in the election process. Additionally, Madam Speaker, the bill seeks to make it an offense to knowingly nominate a person who is not qualified pursuant to Section 61 of the Constitution or is disqualified pursuant to Section 62 of the Constitution. Provisions are also made to make it an offense to knowingly consent to be nominated where the person is not qualified pursuant to Section 61 of the Constitution or is disqualified subject to Section 62 of the Constitution. Madam Speaker, in 2013, a Commonwealth Parliamentary Association Observer Mission team observed the general elections. The final report of this observer mission contained the following recommendation in relation to campaign finance. The existing provisions of the elections law could be reviewed in order to ensure meaningful scrutiny of campaign expenses declared by the candidates. Such a review could also reassess the current levels for campaign expenses and clarify the definition of election expenses, particularly regarding the prepaid services and goods used during the campaign period. Clearly defined, realistic, and enforceable campaign financing rules could reduce the role of money in elections and politics in general. Close those quotations. Madam Speaker, in response to the observer mission recommendations and other recommendations that have been made, the bill seeks to adjust upward the base campaign financing limit from CI 35,000 to 42,000 for candidates running not associated with a party, and from 30,000 to 36,000 for candidates, for each candidate of a party. Madam Speaker, these figures are based largely on the rate of inflation since the limits were first set in 2004. Madam Speaker, with advice from the Postal Services, the bill also seeks to amend the elections law to reduce the delays in sending and receiving postal ballots by making provisions for postal ballots to be sent and received via trackable courier service. Postal ballot instructions are to include a return deadline of 2 days prior to polling day. The postal ballot being returned by trackable courier service is to be paid by the voter, while the elections office is to utilize the Cayman Islands Postal Service Express Mail to dispatch postal ballots. Madam Speaker, I'm excited about the proposal that will amend the elections law to provide an application to be registered as an elector to be made electronically. While this provision will affect future registration processes and exercises, the proposed amendment does allow the elections office to augment, so it's augmenting, not mandating, traditional paper-based registration with a more efficient electronic registration. Madam Speaker, recognizing that in most cases the 19 single-member electoral districts represent smaller number of registered electors than the previous mixed-member electoral district system, it was deemed to be critical that the elections law have provisions to recognize that an elector shall have one ordinary resident and gives the registering office the power to request additional information to assist in establishing or confirming the ordinary resident of an applicant or an elector. And Madam Speaker, this is, we believe, is critical. The elections office have been going door to door to ensure that the register is updated, and so far 2,400 persons have provided updated information to the elections office, and their work is still ongoing. Madam Speaker, the public scrutiny of the register of electors, and in particular the changes to the register, is an important part of checks and balances to ensure that the register of electors is accurate. The current requirement is to publish a full revised list and a full official list 4 times per year. In effect, it makes it more difficult to notice the changes to the list of registered voters because we're publishing it 4 times. To this end, Madam Speaker, the bill is seeking to remove the requirement to physically publish the revised list, an official list, every quarter, and instead publish one full list annually and a list of the changes to the revised list each quarter. Madam Speaker, I'm aware that there has been considerable public discussion on Clause 15 of the bill, in particular, the matter of mandatory registration of persons operating like a party. Madam Speaker, I want to assure this Honorable House that the intention of this bill and the Elections Office in practice is not to enforce independent candidates who are loosely aligned into registering, but to help to ensure that those groups operating as political parties do not have an unfair financial advantage. Madam Speaker, to ensure that the wording of the bill aligns with the intent and based on comments we have received, I'm pleased to share that the government is proposing a committee stage amendment for Clause 15 of the bill, and we will speak to that during the committee stage, but I can just say that it removes the wording which was interpreted as making party registration mandatory and basically allows the supervisor of elections to deem a group to be nominated. To deem a group of nominated candidates whose activities indicate that they have come together to contest an election to be collectively treated as a political party for the purposes of Part 5 of the Elections Law, which, Madam Speaker, is a part of the law that deals with campaign, which is part of the law that deals with election expenses of candidates and political parties. Madam Speaker, in an effort to allow persons who have difficulty reading, Madam Speaker, in an effort to allow persons who have difficulty reading to maintain their dignity and vote unassisted, the bill contains a provision to include, in addition to candidate's name, the candidate's photograph and the symbol of the party to which the candidate belongs, or a symbol indicating an independent candidate. Madam Speaker, we believe this is a good change that will help many of our voters to ensure that they vote for the candidate of their choice. Madam Speaker, when a voter is unable to vote unassisted, the elections law provides for the voter to instruct the presiding officer to make the ballot, to mark the ballot in the manner in which the voter intends. The existing law also provides for a friend to observe the process and to ensure the presiding officer marks the ballot in a manner directed by the voter. Madam Speaker, concerns have been raised over several elections that I guess we can call them professional friends have been using the provision in the law to get first-hand information as to how voters voted, and in the worst case, to place undue pressure on voters to ensure they voted in a particular way. In addition to including the candidate's picture and symbol on the ballot, this bill seeks to end this practice. Madam Speaker, in closing, as can be seen from the snippets of our elections history, the Cayman Islands has an election system that is continually evolving and improving. Madam Speaker, with this bill, it is envisioned that the Elections Office will continue to deliver world-class elections and administer general elections that are lawful, free, fair, and transparent, with results that are widely accepted. And Madam Speaker, it would be remiss of me not to recognize our new elections team, headed by Mr. Howell and ably assisted by Mrs. Bothwell and Mrs. Glasgow. They've been doing a fantastic job. We are going to need their expertise, as it would appear that for the first time in our history, we're going to have over 20,000 registered voters. So that's a large number. We're moving to single-member constituencies. So I do want to recognize the hard work that the Elections Office has been doing. And unfortunately, it's just going to get a bit harder. But we do believe that the changes, the amendments in this bill is going to make our elections, the elections that are about to be carried out next year May, free and fair. Thank you very much, Madam Speaker.
Does any other one wish to speak? I recognize the honorable member from Northside.
Thank you, Madam Speaker. Madam Speaker, I rise to make a short contribution to the debate on the Elections Amendment Bill 2016. First of all, Madam Speaker, let me thank the government for bringing this election bill at this 11th hour to address the recommendations and findings of the Electoral Boundaries Commission 2015. I believe that report was tabled in November 2015, if I remember correctly, so almost 1 year ago. Sarge, can I have the... So, Madam Speaker, as one of the long-time advocates in this country for single-member constituencies and one man, one vote, which campaign I started when we did the 1972 Constitution.
I'm sure the member meant one person, one vote.
Madam Speaker, the Attorney General has chastised me many times that our legal system is not gender sensitive. I'm not talking Spanish, so, but if one person, one vote is more politically correct, I don't have a difficulty in using.
It's more positive, humanistic correctness. Please continue.
I stand corrected, Madam Speaker. Madam Speaker, I am particularly grateful that the 2015 report did not suffer the same fate of the 2010 Electoral Boundary Commission report. And Madam Speaker, let me make it clear in the onset that I support and will vote for the clauses in this bill that establishes 19 single-member constituencies, one person, one vote, and the consequential amendments required to the law thereto. But, Madam Speaker, there are several clauses of this bill that I do not support, such as those that deal with the draconian, unilateral authority it gives to the elections supervisor in relation to political parties. And, Madam Speaker, I accept the Deputy Governor's position, and I have seen the amendment that he has filed. Unfortunately, Madam Speaker, I think that amendment is even more draconian than that which was circulated in the bill, in that at least Clause 15, if you didn't agree with the unilateral deeming by the supervisor of election, you could appeal it to court. This offers no such recourse in this amendment, and I have a big problem with that, Madam Speaker. Madam Speaker, I disagree so strongly with some sections of this bill that I have filed some 9 amendments to the bill. And Madam Speaker, let me take the time to go through the clauses in the bill and clearly identify those that I agree with and those that I disagree with. Madam Speaker, I have no difficulty with Clause 1 and Clause 2. But, Madam Speaker, I would have preferred, if we were going to deal with the principal law in relation to the appointment of the supervisor of elections and the deputy supervisor of elections, we had moved to an electoral commission and established a proper electoral commission far removed from the governor's office, which is what I believe most of the members in this current legislative assembly have at one time or other advocated over the last several decades. And Madam Speaker, while Clause 3 gives the governor the authority to appoint a senior civil servant as supervisor of elections, and in the absence of a proper electoral commission, I can accept that. But, Madam Speaker, Clause 4 of the bill gives the governor the discretion to appoint no less than 3 persons to be deputy supervisors of elections. And those persons shall A, hold an office in the public service, B, have formerly held an office in the public service, or C, if not previously employed in a public service, be a person who has extensive experience as an elections officer. Why do we just make that very simple? And simply say, and I have filed an amendment to try and achieve this, is that the governor shall, in the governor's discretion, appoint no less than 3 persons to be deputy supervisor of elections, and those persons shall have extensive experience as an election officer. Why do we have to first consider public service? If you can't find anyone, you consider retired public service. If you can't find anyone, then you can go outside the service to somebody who has experience. Then it has to be a much simpler solution to simply say the governor must appoint the 3 persons that the governor selects as deputy supervisor of elections must have extensive experience as an election officer. Then it gives her the remit right back. I've already been corrected once on the agenda, so maybe I should say he or she, or she or he. Not sure which one should come first. So, Madam Speaker, again, I don't know why we want to complicate this process so much by having all of these alternatives. Madam Speaker, Clause 5 sets out the 19 electoral districts in the three Cayman Islands, which I agree with and which I wholeheartedly support. I don't have any difficulty with Clause 6, 7, and 8. I do have some concerns about Clause 9, 3, where it says the registering officer may, upon the receipt of an application or to confirm the ordinary residence of an elector, request in writing any information which he deems necessary to determine the ordinary residence of that person or elector. And I believe that leaves it kind of wide open. I believe there's certain documents that he could ask for, such as land register papers or utility bills or something, or an affidavit from other people in the house or something. But if we just leave it out that he can ask for anything, he might want your great-great-great-great-grandfather birth certificate, and you can't find out because that's in Aberdeen, Scotland. So I would like to see, maybe the Deputy Governor may want to look at that and see if we can tighten it up a little bit. Clause 11 and 12, I really don't have any big difficulty with those either. Clause 13, Madam Speaker, introduces a new section to the legislation which gives the registering officer the power, it seems, to object to a person that the registering officer has already registered. And I wonder why they would register them in the first place and then turn around and object to them being registered. Because there's certain criteria under the law and the Constitution which have to be met to be registered. If I'm reading it wrong, I'll be happy to be corrected, but it seems to me that the current legislation provides for other persons who may object. And I don't know why we need the registering officer to have the authority to object to their own registration process, if I'm reading it correctly. Well, I don't. I think once you register as a Caymanian to vote, you should remain on the register that you did. I think we have to continue to allow Caymanians to be part of their country, even if they've migrated for economic reasons or other purposes. And I don't support this residency period. So, Clause 14, again, is a consequential amendment because of the introduction of the Mental Health Commission, and I support that. Now, Madam Speaker, Clause 15, which I know the Deputy Governor has said and has filed an amendment to withdraw it, so but I wonder the genesis for clauses 15, 16, and 17, and to a lesser extent 18, which seems to be an attempt by the government to entrench political parties in the system and somehow reduce the opportunities of the persons who wish to run independent. And I don't know whether this is a government reaction to C4C in 2013, and whether we think we need to write specific legislation now to do in 2017 what couldn't be done to them in 2013. Because, Madam Speaker, the some of the provisions in, and I had a lot to say about Section 15, but since it's being withdrawn, I will spare the Deputy Governor the chastisement that I was about to offer him on such, how shall I say, Trumpinian, unilateral, non-democratic, dictatorial legislation. Where the supervisors of elections is empowered here, it would be a lot of I. And I still maintain that the amendment is going to get them in a lot of trouble, but I'll discuss the amendment when I get to Clause 69. But some of the provisions in this, Madam Speaker, for instance, in 17, where the principal law as amended in Section 25 is as follows: by deleting the marginal note, don't have a real problem with that, grounds for refusal and revocation, and by inserting after subsection the following new subsections. And I would just remind members that Section 25 says that no political party can be registered between nomination day and the return of the final writ. And I want persons to pay particular attention to that section of the law when it comes to the proposed amendment to 69. And some of this, Madam Speaker, says the supervisor may subject to 4, revoke the registration of a political party. 4, the supervisor shall, in making a decision to refuse to register an applicant or to revoke the registration of a political party, consider all of the factors relevant to determining the political party's purposes, including as applicable the following: the political party's constitution, articles of incorporation, and any other information that may indicate those purposes. B, the political party's political program, annual report to members, fundraising plan, advertising material, and policy statements. The nature and extent of the activities of the political party and its registered associations and candidates, including the nature and extent of their involvement in electoral campaigns, and any of their public statements in support of another political party or a candidate of another political party. Now, Madam Speaker, what are we trying to say here? That if the People's Progressive Movement has in the 2017 election, and they have met all that criteria up above and been registered as the party, and they have 17 out of the 19 candidates in their party, and if they wish to make a public statement in support of me as an independent candidate in Northside, the supervisor of elections can revoke their registration as a party? I think, Madam Speaker, that we're going way beyond what the existing legislation is, and there's absolutely no need for this. I don't remember seeing this in the Observer's report or in any other report. It certainly is not an Electoral Commission report. So again, I ask the question of the government: what is the rationale? What is the grounding? What is the policy? What is the purpose of this kind of legislation? And remember now, Madam Speaker, we're getting back now to the powers we given to the supervisor of the election, not a court. Because they removed, when they removed Section 15, which allowed appeal of the supervisor's decisions to a grand court, there's no appeal to this now. And Madam Speaker, I also filed an amendment because I believe that we should be able to appeal a single court's decision to the appeal court. Now, Madam Speaker, it goes on, you know. D, the funds received by the political party and its registered associations and candidates, their sources and how they were used by the political party, including as election expenses. So if I do what I usually do and borrow money from the bank to fund my campaign, does the supervisor election have the right to ask for my loan papers from the bank to prove source of funds? What is the purpose of asking for the sources if they don't intend to have some action on it if they don't agree with the sources? E, interactions of the political party with other entities that are not recognized political parties that may indicate that it is under the control, direct or indirect, of another entity of that political party is using its status as a registered political party primarily for the purpose of providing financial assistance to another entity? What business is that of the election supervisor? If the PPM decides to pay for an ad as me as an independent candidate? Or to give me one of the couple of their hats and I take the PPM sign off it before I give it away? Whether the political party is a non-profit entity, if it want to be that, it should have to be registered. And if it's not registered, it is not a non-profit entity. Then, Madam Speaker, you can no longer have a president of your political party. The government is even telling you what you have to name the officers of the political party. Why? Section 16 say, by deleting the words president, chairman, or secretary and substituting the words leader or chairperson. Why is it necessary for the government to legislate what in a political party wishes to call its leader or what offices that party decides to have? Madam Speaker, there's another new little section in here that says in 18, the principle law is amended in section 26 as follows. By inserting after paragraph D the following paragraph. E, the address of the political party's headquarters, and by inserting after subsection 4 the following subsection. Supervisor shall, within 14 days of the date for the nomination of candidates in an election, publish the political party register. Why? Are you trying here to address the situation in the Constitution as to how the leader, the premier, is elected or appointed by the governor? Is that what this is intended to do? And therefore, if the political party is not published in that, other people can't form something after that to appoint one person as a leader without a vote on the floor of the assembly? What is the purpose of the registry? Most people in the country know what political parties exist. Again, Madam Speaker, the new section under clause 21, principal law is amended by substituting. Oh, and Madam Speaker, I must point out that they made a very subtle, but I think important change to section under the amendment, the amendment filed by the Deputy Governor to section 22, which again I don't see the necessity for changing what is there. Section 22 currently reads in the existing law, any group of persons who have united to contest an election is eligible to be registered as a political party. They are amending that to say a group of persons who come together to contest an election shall, not is, shall be eligible to register as a political party. Again, I ask the question, what is the significance of the change? If it's accepted that is the people who form the group decision as to whether they want to be a political party and whether they want to provide all of the things that qualifies them to be a political party, if that is their choice, then why do we use the word shall? Then, Madam Speaker, the new 29A which reads, under the bill before us, the supervisor may, where it has sufficient evidence that a person who has been nominated as a candidate does not qualify pursuant to section 61 of the Schedule 2 to the Cayman Islands Constitution, Order 2009, or is disqualified pursuant to section 62 of the Schedule 2 to the Cayman Islands Constitution, Order 2009, apply to the Grand Court for a declaration as to the qualification or disqualification of that candidate. What are we saying here is that the supervisor or the registering officer at the electoral district is not going to make any decisions as to who is eligible for nomination on nomination day. Because I would think, again, I'm not a lawyer, but I would think that we need the supervisor and or the returning officer, or whichever one it is, at the constituent level to make a decision. Is the person duly nominated or not duly nominated? If this is a cop-out because of what happened in 2013, I can't support that. The law provides for them to make the decision, so they're not deciding, they're asking a court, how long is that going to take? 24 hours, 48 hours, 3 weeks out of the election campaign? I know the DG used the word expeditiously. I would prefer to see, if you're going to go down this route, which I don't support, I think that the registering officer or the returning officer, whomever the person is, and the supervisor election must make the decision in accordance with the authority given into the law. If the person who wished to be nominated, was not nominated, and he's aggrieved by that decision, then he can go to court. But are we going to, how long after nomination day do we have to wait before we know who the candidates are for that constituency? Clause 14B. You going backward now? Anyway, and then in clause 2, Madam Speaker, it says that an application for a declaration under subsection 1 shall be determined by the Grand Court, whose decision shall be final and not subject to appeal. I think that decision should be subject to appeal to the appeals court, and that decision is final. But I think you need at least 2 opportunities to get it right. And I also believe that other places in the law where the appeal process stops at the Grand Court should be amended to allow the aggrieved person to appeal to the appeals court. And it only happens every 4 years, so we can have them staying in a hotel and stand by in case anybody want to do it. So not wait Trump come from Timbuktu. Now, Madam Speaker, in section clause 25, which I believe we're setting ourselves up for all sorts of trouble.
Member, did you say clause 25?
Clause 25 of the current bill. Clause 25B, which institutes 1A, which reads, where within an electoral district there are insufficient or inadequate facilities to be appointed polling stations, supervisor with the approval of the governor may by notice appoint a polling station for a particular electoral district in another electoral district. I think that's fraught with problems and danger. And I have filed an amendment to say that they can use mobile polling stations. Because we have mobile units anyway, that we go around for in place of absentee ballots and stuff. So why don't we keep the voting within the electoral district? Because this doesn't say it has to be in the neighboring electoral district, you know. This would allow electoral district in West Bay, which I agree with, but unpractical, to be some part of Georgetown, how it's written. So I believe, Madam Speaker, again, that it makes more practical sense. If you can't find a structure within an electoral district in which you can adequately provide for polling opportunities, safety, security, and everything else, use mobile polling stations. You have them anyway. Because I have some concerns if you have 2 opposing political parties who may be dominant in neighboring opposite electoral districts, and you're going to send the people from this electoral district who support party A into electoral district B, which is dominated by party B, to vote. I don't see again the need for that. I would be much more comfortable with mobile polling stations. Now, Madam Speaker, we get to this. I don't have any particular difficulty with 26, 27, 28, 29, 30, 31, 32, 33. But I do have some difficulties with 34, which amends section 67 in the current law. And Madam Speaker, the Deputy Governor has announced that he is going to file an amendment, and he has circulated it, which introduces 34A of the bill here, which will amend section, which will create a new 69A in the existing legislation, which says, the supervisor may, where a group of nominated candidates appear to be carrying out activities that indicate that they have come together to contest an election, deem that group of nominated candidates for the purposes of this part to be a political party. This part of the law deals with campaign finance. Now, Madam Speaker, again, I'm not a lawyer, so I speak subject to correction. But we are authorizing the supervisor unilaterally, single-handedly, dictatorially, Trumpunian-like way to say that, and I'll give a for instance. For instance, me and the member for Eastern work very closely in Parliament. Everybody knows that. We just happen to buy campaign hats from the same source under the same color. We produce two separate manifestos. Our national issues are the same. Our district issues are different. He is as a speaker at my campaign rally to launch. I'm a speaker at his. The supervisor, and his sole discretion and wisdom, decides we are a political party. And he deems us a political party. A political party, Madam Speaker, I would venture, is a creature of this election statute that has to have certain deliberate characteristics to qualify as a political party. Now, we went through earlier all the things that we have to have as a political party. Constitution, if we're incorporated, we got to make sure we're non-profit. We got to have logos, brochure, everything. We went through that earlier. We don't have none of that. And we don't have no intention of doing any of that. But he deems that we're a political party for the purposes of this section. Now, the question is, does E, that we talked about earlier, apply to having been deemed a political party? Because we decide to go Bordentown and support the fourth elected member for Bordentown and the constituency that he's running. And he's not a political party. So we run afoul of E. So what he can do then? Revoke, or what word should we use? Or deem nation as a political party because we're supporting another independent candidate, or we decide to support the PPM party or the UDP party. He can revoke everybody's registration then because we contravene in the law. And Madam Speaker, the only rational reason to have this draconian provision is because there's a difference on what we allow on the campaign finance for a political party person and an independent candidate. Why is there a difference? A party is made up of individual candidates. The party doesn't get nominated. Each individual candidate has to get nominated for that party. Why do we have to have a difference in the funds? If a group is smart enough to get together to pool their funds for better purchasing power, for better advantage? That, as that Trumponian man would say, that makes them smarter. Why are we concerned with this in the legislation? The simple solution, Madam Speaker, and I have filed an SR amendment, is to amend Section 67 of the law It is 67? Yeah. Currently, Madam Speaker, this is what the existing law says in Section 67. And the marginal note is limitation to election expenses. Election expenses shall not exceed the sum stipulated in subsection 2. 2. The maximum amount of elected expenses to be incurred in respect of a candidate at an election shall be A, where the candidate does not belong to a political party, or there is no other candidate belonging to the same party at an election in an electoral district, $35,000. And B, where the candidate is not the only candidate belonging to a party at the election in an electoral district, $30,000. Madam Speaker, simple solution to that is to say the maximum amount of election expenses to be incurred in respect of a candidate at an election shall be $40,000. And I've filed an SR amendment. Bring the party people up to 40 and bring the independent down 2. Bring them up 4 and bring us down 2. Because how they came up with 36 and 42, don't know. Maybe the financial minister of finance worked out the inflation the last 4 years and put it at that. I don't think so. And then, Madam Speaker, we can get rid of all of this draconian authority to the supervisor of elections. Because I noticed the Deputy Governor, in moving it, spoke to the report from the observers about the necessary for election campaign finance. But they didn't ask for the number be changed. And they didn't recommend that the supervisor have this draconian power. They said we need to tighten it up as to when the expenses are accounted for and when the stuff is used. So if we want to put, as a former governor used to tell us from that year, you know, in Madam Speaker, belts and braces around it, they can put a caveat on it. Any material, irrespective of when it was paid for, that is used from nomination day till election day must be accounted for. So that people can't go and pay for TV time and radio time and 2 million T-shirts before, but they don't have to account it because they didn't buy it after nomination day. That is the kind of electoral financial reform I would like to see. This doesn't make any sense. And let me give you another example. So, Madam Speaker, it takes the supervisor of election 2 weeks. I think it's a 6-week period for nomination, if I remember correctly. So it takes him 2 weeks to designate me and the member for East End a political party. What, he can do that retroactively to nomination day? Or are we entitled to 1/3 of the 42,000 for the first 2 weeks before we are so deemed to be a political party? And for the next 2/3, we have to comply with the 36,000 for the party. Yeah, exactly. They can't declare you seat vacant if you don't comply with this. You know? Now, if you want to talk about electoral financial reform, put some penalties on it. But we simply dress it up, give all this power to the supervisor of elections, and think we've done something. We haven't done anything, Madam Speaker. We haven't done a thing. We've made matters worse. Because it doesn't say, that if it's a group of 2 or a group of 4 or a group of 6, or if you have certain things, he shall deem you a political party. The amendments say he may. So he can decide that one group is to be deemed a political party, but the group that he liked. And this is not, I'm not deeming this, I'm not being personal to the current holder. I want to make that clear. We're talking about the office of supervised elections. But the group that he liked, he can say, well, I don't deem him a political party. Because there's no guarantee of consistency in the decision making. And that troubles me more than all. Because what's good for the goose must be good for the gander. So, Madam Speaker, those are the areas with which I disagree in the current legislation. I have filed 8 or 9 amendments to try and achieve what I can support and what I believe my people would like to see in the legislation. I shall move the amendments at the appropriate time and see where it goes, Madam Speaker. Thank you very much.
We'll now take a luncheon break and reconvene at 2:15 p.m.